contemplated that.
But, Mr. Johnson, a condition still, if you make that $300,000 bond, is that you would be on house arrest. You would be required to wear a GPS monitoring device at all times. Part of the reason, good morning, are you Jonah Ray Johnson?
Yes, Mom.
And this is 25 DCCR 1775. Mr. Johnson is charged with aggravated assault with a deadly weapon. And Mr. Vasquez has filed a motion asking that I reduce Mr. Johnson's bond, which is currently set at $300,000 in that case. Are you calling your client?
Yes, Your Honor.
Mr. Johnson, best you can, raise your right
Oh,
hand.
no, I'm sorry, Your Honor. I'm not. I'm calling my client's mom, Jacqueline Broussard.
Ms. Broussard? Mr. Johnson, if you'll just come around just to the side, right there on the corner. Ma'am, if you'll come right over here, please. Good morning. And would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may proceed.
Thank you, Your Honor. Ms. Broussard, state your name for the record, please.
Jacqueline Broussard.
And you've done this before, haven't you?
Yes, ma'am. Oh, sir, sorry.
And you are Jonna's mom, correct?
Yes.
And the original bond back in September was $150,000. Wasn't that correct?
Yes, sir.
And what went wrong? What was the problem there?
The ankle monitor. We thought it was broken, which that we was led. That was, you know, we called Johnny, and Johnny told us to come in, which we had been talking with Johnny for 2 weeks. But like I say, Johnny said come in. There's something's going on with the monitor, and we also was a payment behind.
Okay.
And but we like.
let me interrupt.
I'm sorry. Go ahead.
That's all right. The bondsman said the defendant has failed to pay for the GPS device. It wasn't charged. He will not respond to surety's attempt to reach him. He cannot be located. Surety feels like his bond is at risk. Now, you disagree with that, right?
Yes, sir.
The bond was never at risk.
No, sir.
Jonna lives with you.
Yes, sir.
You live in Beaumont
Yes, sir.
with your husband.
Yes, sir.
And how many people live in that house?
Me, my husband, my oldest son, and Jonah.
And how long have you been in that home?
Over 5 years.
And the four of you lived there.
Yes, sir.
Was Jonah working when all this happened?
Yes, sir.
Where was he working?
He was working for Jefferson nursing home.
Say again?
Jefferson.
What was he doing?
He was working in the kitchen.
And how long did he have that job? You recall?
I think he had just received that one over there. Maybe 6 months. I'm not. Yeah. Because he just got hired out over there.
And he's 18?
Yes.
He lives with you. He's not. Is he a flight risk?
No, sir. He's not.
Are you worried about him taking off or running
No,
off?
sir. I'm not.
And you wouldn't waste your money if you.
No, sir.
Oh. What bondsman have you talked to?
I had talked to a professional with Kenya, and I had talked also Reed with Lisa.
Which bondsman was this back in September?
I think that was Ella.
That was Ella.
Uh-huh.
Is that who you're talking to now?
Yes, one of them, yes.
And what have your conversations been like with them?
They just ready for me to get in touch with them and see if they're not going to be reduced. I just had one text me this morning.
Have you talked to them about what amount you would want that you're trying to get reduced to? What would be reasonable?
At least 100,000. We had talked on that.
Well, it was 150,000 back then.
Yes, sir.
So it's not really realistic that that the court would drop to 100,000 now.
Mm-hmm.
Are you asking the court to reinstate I don't know if reinstate the correct word, but to go back to the $150,000?
Yes, sir. Yes, sir.
Is that something you think you could work with?
Yes, sir.
They probably want you to sign a contract for $15,000.
Yes, sir.
I think 10% is
Yeah, yes, sir.
Would you make sure there was no discrepancies or mistakes or misunderstandings about the GPS monitor system?
Yes, sir.
And what else would you like to tell the judge about the bond?
I'm not the one. We already prepared to my client, Jonathan.
Have you seen the video in this case?
Yes, ma'am.
Okay.
I have talked to my son. Yes, ma'am.
You've actually
And-
seen it?
Yes, ma'am.
Okay.
The whole video.
Okay. Anything else?
Nothing else. Your Honor.
That was
Questions of
actually,
this
that was
witness?
actually one of my questions I was going to ask this witness is whether or not she's seen the video, Judge.
Okay.
In addition to that, Ms. Broussard, are you aware that your son in the last 5 years has been arrested for 9 different offenses?
Excuse me?
Are you aware that in the last 5 years, your son has been arrested for 9 separate offenses?
9?
Yes, ma'am. Evading arrest as a juvenile, UUMV as an adult, possession of a controlled substance, unlawful carry of a firearm, failed to ID, possession of a controlled substance, possession of marijuana, and 2 additional unauthorized carrying of a weapon. Were you aware of those arrests?
Yes.
Okay. Now, the gun that your son allegedly carried back on August the 31st of 2025, during that shootout at the Pine Club Apartments, do you have any idea where you got that gun from?
No, sir.
Are you aware that a bystander was shot during that melee?
Yes, sir.
All right, that's all I have, Judge.
Okay. Any other questions of this witness?
No, Your Honor.
Thank you, ma'am. You can have a seat.
Thank you, ma'am.
Excuse me.
Any other witnesses, Mr. Vasquez?
No, Your Honor.
Mr. Pullman?
Judge, one of the items of evidence that I planned on introducing was the video from the shootout. It sounds like the court vividly remembers that. So if the court doesn't wish to see that again, I want to.
Let's just quickly play it. I want to, I'm refreshing my memory by taking, well, first of all, I'm gonna take judicial notice of the court's file. I have reviewed the probable cause affidavit, which is what reminded me of the facts of the case. And I guess it was the other
It was the
case that
co-defendant.
we had a bond hearing on. Is
Yeah,
that
yeah.
correct?
Well, no, I take it back. It was this defendant when he was represented by Brittany Holmes, if I'm not mistaken.
So I've had a bond hearing, watched the video on this case.
Yes, Judge, if I'm not mistaken. In fact, when you look at my notes, yeah, that would have been January 13th of 2026. My notes include that there's a defense motion to reduce the bond. We argued, yes, you heard evidence and testimony, and that you denied the motion back in January of this year.
So this was after the AFRS, and the bond was at 300,000 on that date for the same bond hearing.
Yes, Judge.
Your motion's denied. I've already heard all the evidence.
Well, there is something, Judge. I think that it's at least, if you're going to deny it, I think you may want to consider it as far as whether or not the bond is sufficient. As it states, it's just a 5-minute clip of
Go ahead.
a jail phone call that I've added subtitles to. If I could do that, I'm happy to bring my sponsored witness, but if you'll stipulate to it.
No, I'm going to object to it to relevance. Your Honor.
Bring your witness, please.
Yeah. State calls Captain Michael Pond.
Good morning, sir.
Morning.
Thank you for your patience this morning. If you'll please raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. Go ahead.
Captain Ponder, would you state your full name for the record, please?
My name is Captain Michael Ponder.
And Captain Ponder, very briefly, what do you do? What are your duties at the jail, over at the jail? That's right, department.
I'm the custodian of records for the Jefferson County Correctional Facility.
And you're familiar as a custodian of record with the recording equipment there at the jail, correct?
Yes, sir.
And it's capable of making an accurate recording.
Yes, sir.
Each inmate is issued a unique identifying number, correct?
Yes, sir.
And that's one of the ways to identify who makes certain calls from the jail, correct?
Yes, sir.
Have you had an opportunity to review where I am marking? Judge, you want me to mark this as states 2 or 3? We entered one in the first hearing back in January. I can do it 1. However you want to do it.
I mean, it's technically a new hearing.
Okay, I'll do 1. Okay.
One's fine.
All right. You recognize this USB drive?
Yes, sir.
How do you recognize it?
Because I listened to it this morning.
And are these your initials in today's date that's on this USB drive?
Yes, sir.
I'm marking it as State Exhibit number 1. You listened to it. Do you have any doubt that it's a fair and accurate copy of a jail phone call or recording of a telephone call made by an inmate, this inmate, from the Jefferson County Jail?
No, sir, no doubt.
All right, Judge, state off, state so.
Mr. Vasquez?
How, good morning.
Yes.
How long is this video?
This is
the
an audio.
recording,
It's
I'm
on.
sorry, the audience.
It's about a 5-minute excerpt from a 14-minute and 20 some odd second phone call.
Well, so it's been altered.
It's been included, yes.
Object to the alteration, Your Honor.
Judge, what's on here is the original 14-minute long video as well as the shortened 5-minute video with the subtitles added. So the original's on here.
Okay.
And by the way, I gave it to Mr. Vasquez yesterday, and he's had a chance to preview it.
States one, with both, will be admitted.
Permission to post, Judge?
Yes.
Judge, can I finish my objection?
Sure.
There's a object to the alteration, and then there's a transcription. I object to that as hearsay, where you're given
The subtitles.
the subtitles of what you think they're saying.
Do you disagree that the subtitles are correct with what you hear?
I don't know, Your Honor. I just object to it being hearsay.
Oh,
Or is it hearsay?
The subtitles are on it to what it's someone has written in what they've transcribed the conversation to be. I object to that as hearsay.
Mr. Coleman?
Judge, if the audio is not hearsay, which is a statement made by a party opponent, then the subtitles are therefore not hearsay. Judge, it's
I
just-
obviously will be able to listen myself and your objection's overruled. It's admitted.
permission to publish. Judge?
Yes, and that's both the excerpt as well as the entire. And thank you, Captain Ponder.
Yes.
Maybe reported or monitored.
He came back in, he said, we still ain't gave probation. The lawyer told them do probation shit. I was actually looking at it, lawyer trying to ask probation shit. She was like, man, there's too much shit been going on. It's like a wild west. He talking about she was like, he got write-ups, he be jumping in and that little shit up. But she like, I gotta make an example. But oh my man, crazy people went crazy for me. Wow. No, he saved people screaming that shit. They say, man, world star type of shit. LeBron all over the world. Coming out of that, first it was cool, he was chill. Kept asking, bitch, you good, you good, you sure you good, bitch, and they good. Like, I'm good with whoop. So one day, he just snapped. CO said something to him. They said, what, bitch, had what the play? So I get to CO and they want to punch him. They go, like, I'm 60 weeks. Whoop. Niggas, so he ain't trying to CO and trying to punch like, boom, he smacked the motherfucking computer, punched that bitch. Break the motherfucking computer. They come, he been in the door, man, since they came out, I thought he been in the door. That bitch 25, so it was trick, so good, good. Hey, you ain't bitch. Anyway, you gotta do at least one, yeah. I mean, that's his taxes. If you go down that trip, he gonna put it up for college for $5. Yeah. And they know it's his whole point. That's if my little folks go to that first time about leave your sentencing to the judge. And I said, hell nah. Take my shit to trial. I said, then boom, I got my bus for the governor. I seen all my evidence and shit. That shit bullshit, bro. Let me take this to trial, bro. They gonna drop the charge. So I took take the trial. Ooh, my lawyer's good. I need to look at the paperwork and shit like, oh, you good? You fit? You give it some time. But I know it's gonna take time. Because everything that's going on right now, they ain't making it no better. My shit, but like I say, they come, even if they come like this, 5-year cap, they gonna say they off probation with a 5-year cap. I take that. I want to be careful. I want it 5 years. But if they do, I put like 2.5 on that bitch. Oh, come on, man, bro. Thank you. I have some bank time. You see, I'm gonna have some bank time. Sorry, I got 5 months bank time right now. You mean that 5 months? 5 months, bitch. Damn. But this was 5 months. Too much I did, boy. This shit look like shit over. Very good point of the phone, because at that time, really, it's kind of been flying by. It's just like, once you get in, it's going to just flying by. Sure. That shit. Very vicious. So, man, wow, this is something. I ain't a mother, but that shit, very big. Something. And cause they have been around young, it's hard to do it. I stay out the way. But you know, push gonna come to shove, some shit gonna happen. Boom, you know. Yeah, cause like, that was my first write-up. Like, bitch, I've been chilling, talking, quiet, doing that to nobody. That there's just write up, got another write up, I got fire write up, other fire something. But at that time, they moved to this door. Shit. It was straight out to the top. So I do it, put me on game day, so it's going down. Like, shit. So, I guess then my first came in, so I was a KO, boom. I said, it's coming to hell, leave, and go back. You know, this can be a lot of deals like this, I'm good. I'm like, hey, I can't back to deal, like, right? So, I'm like, yeah, oh, I'm just going, they can get out here for a while. Like, the flood, you know, see this, you know, I ain't gonna figure the world like this, and have to get it. Good, and he, like, yeah, shit, say, give a nigga probation for worse shit like that. Good, this how I move. You come out on top with it. But this you probation for when you get it. They just gave my other part of my free world part, they had 3 robberies, tag. Gave nigga, ISL, fuck 3 months and 10-year probation. That's like that nigga, you can't even believe. That's what I'm talking about. They gave ISL 3 months, he had 3 months ISL, he got 10 years probation. After he was already on probation for 10 years. But crazy, him and the dude, they got us to fight with the court the same day. You know.
That's all I have on that, Judge. State has no further witnesses.
All right, anything else?
No, Your Honor.
Okay. So at this time, I am going to deny the motion for a bond reduction. And I guess, the issues, I've looked at the bond, the affidavit for them to release surety. It's not just the GPS monitoring device. They obviously were having a hard time getting in touch with you for whatever reason. So I think that makes obviously one of the criteria under 17.15 for bail is that obviously you have to follow all of the rules and conditions of bond, which is with your bondsman as well. And so we will reset your case for an announcement, and Mr. Vasquez will visit with Mr. Coleman, get any offers in your case, and we'll either take a plea if you wish to take a plea at the next court date, or if you don't, we'll do a rejection and get your case set for trial. All right, you can go back with the bailiff. Good morning. Are you Veronica Randall?
Sure.
And Ms. Randall was previously in court in clause numbers 25 DCCR 0246 and 0247. Entered pleas of guilty to theft of property with previous convictions, a state jail felony. Also entered pleas of true to prior convictions, which enhanced this to I believe, second-degree felony for punishment purposes. The agreement was for a cap of 6 years in prison. I've received and reviewed that pre-sentence report. Have you all both had an opportunity to review that report?
Yeah, Sean.
Yes, sir. Are there any additions or corrections to the report?
All good? What you read? All accurate? No, no additions.
Judge, I don't have any additions or corrections. I would just state if it's the appropriate time for the court. When I look at it, I have some empathy for Ms. Randall based on the comments that she made. But how much can we take her out of her word with her criminal history? The court will recall you previously rejected 4 years in this case. I'll defer to whatever you think appropriate. Yeah, Judge.
I also have taken judicial notice of the jail incident reports. You both should have copies of those. Have you both had an opportunity to review those as well?
Yes, sir.
Yes, Sean.
All right, Mr. Vasquez, you may proceed with argument.
Your Honor, I know Ms. Randall's had probation a couple of times in the past, and it didn't work out for her. But I'm arguing for anything that does not involve incarceration. Ask the court to just grant her probation with every condition, and that the court thinks best would help her to quit offending. And in lieu of that, I mean, in the alternative, Your Honor, I'd ask for something less than the 6 years, if she's going to.
Anything else, Ms. Mulvaney?
Judge, I don't have any additional comments. I would just state that our agreement initially was to dismiss the new case because she already has the sequence felony priors that would enhance anything further. But if the court disagrees with that, we can visit about it after the sentence.
So, Ms. Randall, I made some notations on this pre-sentence report.
This is the part every defendant hopes goes in their favor. The judge has reviewed the history, heard the arguments, and now he's explaining exactly how he reached his decision. Pay attention to what he focuses on most.
Is what requires or makes you go out and do what you've done. Literally since 1981. Your first theft that I have here was from an arrest from 1981. Then I have one after another misdemeanor thefts through 2018. Then we've got, starting in 1986, a robbery and a theft. And then we've got 13 when you are not incarcerated and not on probation to get the help that you need if that's what you think is the problem. I think the problem is you just like to go steal or rob, because I mean, we've got robbery, aggravated robbery, another robbery. Anyway, so at this time, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you also entered your pleas of true to those prior convictions freely and voluntarily. In cause number 25 DCCR 0246, find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find the other previous convictions true, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections.
6 years. After decades of arrests, theft cases, and prior convictions, the judge has made his decision. That's a life-changing sentence being handed down right now.
It's true. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I will sign a dismissal in clause number 25 DCCR 1686 as part of this agreement. I'm handing you the trial court certifications in each of your cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Vasquez. Right, ma'am, you can go back with the bailiff.
Thank you.
Good morning, ma'am.
Your tan fam,
Yes, sir. Yes, ma'am.
and Mr. Pham is here in cause numbers 25 DCCR 0909, 25 DCCR 1039, 26 DCCR 0353, 0354, and 0355, all charges of theft of property with previous convictions. And what is the announcement?
Judge, this is one that, after speaking with Mr. Pham and going back through it, I will definitely need some just a little bit additional time. If you notice, even that's the names that appear on the docket, they're a little different as far as how they are. As well as it was a situation where I believe he had bonded out and then some more cases came in after the fact.
Several were indicted at the end of February, Your Honor.
With,
And they were
and those dates are actually before
Right.
correct.
the first two dates.
So I'm going back through to try to get everything together
Okay.
with him.
Okay. Any issue?
And no, Your Honor, no reason not to reset, just to
All right.
make sure we have everything straightened out.
Okay, I'm just going to reset your case, normal reset, so that Mr. Lewis can kind of get everything straightened out, talk to you, make sure where everybody is, and then we'll get an announcement at the next court date.
I will be a good amendment.
Okay, thank you. You can go back with the bailiff.
I'm glad to see you.
Sure. And will.
Good morning. Are you Derek Schinkel? And this is 25 DCCR 1797. Mr. Schinkel is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, I've been out talking with Mr. Schenkel, going over the case with him and everything. My understanding is that it's his desire to retain John West on this matter. As of yesterday, I believe his family was putting the money together close to it where they can get him retained
Okay.
on the matter.
So, Mr. Schinkel, what I'm going to do, I'll just do one reset. If y'all can get Mr. West hired or someone, that's great. Until then, Mr. Lewis is your attorney. He'll still have all the information and work on your case. If you guys can't get someone hired before that next court date, then we're going to need to go forward. Obviously, we'll get it taken care of one way or the other at the next court date.
Yes,
Okay?
ma'am.
You can go back with the bailiff.
Thank you.